Mr. Freeman's making great hay out of his innocent till proven guilty shtick. He doesn't understand it, and because he doesn't understand it, he is misinforming other people. Innocent till proven guilty arises from Coffin v. United States. It is a terrible decision to read. I don't recommend it. All the pre-1900 cases are terrible reads. Long-winded, hard to follow, terrible. But it comes from a jury instruction. The 44th charge asked and refused was as follows. The law presumes that persons charged with crime are innocent until they are proven by competent evidence to be guilty. To the benefit of this presumption, the defendants are all entitled, and this presumption stands as their sufficient protection against, or unless it has been removed by evidence proving their guilt beyond a reasonable doubt. Although the court refused to give this charge, it yet instructed the jury as follows. Before you can find anyone of the defendants guilty, you must be satisfied of his guilt as charged in some of the counts of the indictment beyond a reasonable doubt. So that's where it came from. It came from a jury instruction. The defendant wanted the court, and the Supreme Court agreed, that the defense should have been able to have the jury instructed in this manner. But it's a jury instruction. And innocent till proven guilty is a jury instruction. Jury instructions come at the end after they've laid out their cases. And there you go. So due process is entirely different from entirely different from the innocent till proven guilty. Due process requires reasonable suspicion for detention. It requires probable cause for arrest. You get in front of a magistrate to have them determine whether or not there in fact is probable cause to support the arrest. You have your right to the jury trial. I mean, this due process starts from the moment of detention or arrest. So you don't like due process, or you don't like the form it takes, that's fine. There are things I don't agree with, but innocent till proven guilty was never intended to keep someone from being put in jail prior to their hearings. It was never intended to prevent someone from having conditions put upon their bail or their bond. And it was never intended to prevent idiots from having their bail revoked for refusing to sign the bond agreement. I hope that clears things up. Mr. Freeman is uninformed and misinformed, and he's uninforming and misinforming people. So there you go, Seb. I hope that makes sense to you. Have a good day.